pleasure talking to you today. I'm Claire Norins. I direct the UGA School of Law's First Amendment Clinic. I'm joined by Frank Lamonte, who is Senior In-House Media Counsel for CNN, and also Jerry Weber, who is a constitutional litigator specializing in First Amendment cases. So now I'm going to switch it over to Frank to talk to us a little bit about the basics of First Amendment law.
Good morning, and thank you for the opportunity. Yeah, and I should clarify, my day job is at CNN, but I am wearing my hat today, both as a proud board member of GFAF and also as an adjunct instructor with the UGA School of Law. I've done a lot of teaching and research on this issue of the rights of public employees over the years, and so I have my researcher hat firmly in place today. So why are we here? I think, while the issues that we're here to talk about are evergreen and we could have this conversation at any time, GFAF really felt like it was important to furnish some information to people, both employees and employers, people on all sides of the conversation, about where the government's authority begins and ends when they attempt to punish somebody for the content of their speech. And we see this going on. There are waves of these from time to time. And right at the moment, the headline item is, of course, people being fired from their jobs or otherwise disciplined because they were perceived as having posted material on social media that expressed inappropriate sentiments about the horrible murder of Charlie Kirk. And based on that, hundreds, if now thousands of public employees around the country have been brought up on disciplinary charges for the content of those messages. And so this raises the question, right? What can the government do and not do in that workplace setting when somebody says something, oftentimes on social media on their own time, that's deemed to be inappropriate, unsuitable, reflect unfavorably on the organization? So let's look to the next slide, and we can talk a little bit about just kind of the First Amendment baseline, right? These are the rules that apply outside of the workplace. These are the rules that govern what people can and can't say without government intervention when you're wearing your citizen hat as opposed to your employee hat, right? And we'll talk about the workplace in a moment, right? But when you're wearing your citizen hat, when the government is acting as a regulator, regulating the speech of its citizens, the short answer is there's almost nothing that the government can do to you. Content-based or viewpoint-based restrictions on speech are presumed to be unconstitutional, and there's a heavy burden on the government if they want to either restrict in advance or punish after the fact based on the message that the speaker is expressing, as opposed to like the method or the manner of the speech, right? So a regulation that says don't use an electric bullhorn in residential neighborhoods after 2 a.m., that's not about the message, right? That's not about the content. That's not about a viewpoint. That's probably okay, but don't use an electric bullhorn to express support for the Green Party. That's a message-based regulation, right? And that's not going to be constitutional. Furthermore, right, what the court has said over and over again is anything that looks like a prior restraint on speech, something that requires the government's permission before you speak, is always going to be presumed to be unconstitutional. In fact, the Supreme Court has never authorized a prior restraint, even in very extreme circumstances like publishing leaked classified documents. And so the court has never countenanced the idea that the government can prevent you from saying something that you want to say. And I should say doubly so when that directs itself to anything that looks like a matter of public concern, right? A political or a social issue. If the government issues a regulation that's vague or overbroad, doesn't give you enough guidance about how to tailor your behavior to that regulation, it is going to be unconstitutional, both as a matter of First Amendment law and also as a matter of due process, right? Often these regulations can be challenged as failing to provide due process. A regulation, a rule, a statute that said everybody has to speak appropriately. That would be an unconstitutionally vague and overbroad regulation, right? It'd be struck down readily by the courts, and it would be struck down facially, right? It's possible to go to court in two different ways on a First Amendment challenge. You can get into court and you can say, well, I think this whole regulation is unconstitutional on its face as applied to the whole world, or it was used in a way that was unconstitutional as to me, right? Maybe my speech was selectively singled out for punishment based on my viewpoint, while other people were able to say similar things without punishment, right? So that's the baseline, right? It should be understood that the First Amendment is really, really strong medicine. And outside of that employee-employer setting, there's almost nothing, outside of threats of violence, the threatening to assassinate the president. Outside of those very extreme cases, almost nothing the government can do based on the content of your speech. Now let's turn to the next slide and look at how this might change in the workplace, right? First thing to know is that you do not surrender all of your First Amendment rights at all just by taking a government job, right? And we talked about state action in the last slide, right? Everything that we say here is about public employment, right? Federal government, state government, local government, school district, county commission, police department, sheriff's department, whatever, right? Any level of government is bound to adhere to the First Amendment, including in how they treat their own employees. And this is different from the private sector, right? You work at Walmart, you say something that your boss doesn't like, that's it, right? My way or the highway, out you go. But in public employment, it's a little different. And these are the rules that the Supreme Court has set forth for us. The foundational case, the one that really sets the rules of the road for what the government can and can't do when it's wearing its employer hat, is this Pickering case, right? And in this case, Marvin Pickering, he's a school teacher in Illinois. He writes a letter to the newspaper that criticizes the spending priorities of the school district. And he's dragged in and fired based on the content of this letter. And the case gets all the way to the Supreme Court, which says, no, you can't just do that. You can't just summarily fire people from public employment because you don't like what they said. Instead, it is going to be the government's burden to show that when an employee is speaking in his citizen role, right? So writing a letter to the editor, not something that he was assigned to do as a teacher, that the government is going to have to show some overriding disruption to the functioning of the workplace, right? He made it harder for the agency to function. And in that case, of course, there's really no such showing. It was just a controversial statement, but it wasn't like the school somehow couldn't do its job anymore. And so he had a good First Amendment case. And this is still the framework that applies even today, almost 60 years old, but still the framework that applies even today if an employee challenges their firing. But over the years, the Supreme Court has kind of put some gloss on the Pickering rule. And one of the big ones comes in 1983, the Connick case, where the court says, well, Pickering is the rule, and that Pickering analysis, that balancing test, is going to apply when you are speaking in your citizen role and you're commenting on matters of public concern. But when you're just complaining, you're just belly aching about like your own job conditions, says the court, that's different. We don't afford that any particular First Amendment protection. So somebody who just goes public with a gripe about not being paid enough, that person is not going to get the benefit of the Pickering protection because it's considered a purely personal grievance, says the court, right? Didn't tie it into some larger matter of public concern the way that Pickering did. Then in the Garcetti case, the court sort of takes another bite out of this protection and says, well, Pickering is still the rule when you're speaking as a citizen on a matter of public concern, but when you are doing something that's actually your job, right, you lose the First Amendment protection, and the government has a free hand to regulate what you say and punish you if they disapprove of it. So in the Garcetti case, this involves a prosecutor who was basically writing a memo, and he writes the memo in a way that is 180 degrees contrary to what his supervisor wanted. And he gets demoted for this. He loses some opportunities at work, and he sues. And the court says, well, no, writing the memo was exactly what you're paid to do on the job. And so you can't claim First Amendment protection to basically defy your supervisor, and writing the memo in a different way, you lose. So that's the framework that the court has set out. And now I want to turn to the most recent case that where the court has weighed in on the rights of public employees, because it's so important and it's often overlooked. That's the next slide, please. So for years after the Garcetti case, it was kind of perceived by some of the lower courts that, oh, well, the Supreme Court has now unleashed employers to go ahead and fire people at will for anything that they say that relates to their job or pertains to their job or involves knowledge that they got on their job. And then in the Lane v. Franks case, very important case, Supreme Court's latest case about free speech in the public sector, the court rolls that back. The court clarifies that no, 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 Garcetti is not open season on public employees. They still have robust First Amendment protection when they are speaking as a citizen about a matter of public concern. And this Lane case was sort of this classic whistleblower scenario. Lane works for the community college system in Alabama, and he blows the whistle because he believes that a politician was put on the payroll in a no-work job, which was corrupt, ends up giving testimony about this and gets fired for doing it. And the Supreme Court says, well, no, this is classic Pickering speech. This is speech about a matter of public concern. And it's not like you were paid as a college administrator to go testify in front of a grand jury. That's not your job duty. And when we said in Garcetti that speech is unprotected if it is a job assignment, that's what we meant. We meant a job assignment, not speech that relates to your work or derives benefit from the expertise that you have at work. All of that stuff says the court remains protected. And so that's very important as a boundary for employers to recognize, right? That just because a person is talking about their work or using expertise or knowledge that they gained at work does not mean that their speech is unprotected. Claire, do you want to take it from here or shall I continue?
I have this is still you, Frank.
I'll talk about this. All right. So over the years, right, we live in the 11th Circuit here in Georgia, and the 11th Circuit Court of Appeals sets precedent for the state of Georgia unless something gets to the Supreme Court and gets overturned. So it's valuable to know a little bit about what the 11th Circuit has said over the years about the rights of public employees, right? So when we say that the Pickering balance test protects you when you're speaking as a citizen, one of the recent cases where the court has weighed in is this D'Angelo case out of Florida. What they said is, well, look, when you're the principal of a school and you're making a policy statement about the school, of course, that's regarded as part of your official duties, right? And one of the takeaways from this case is that when you're a high-ranking official at the agency, when you're a person who like normally speaks for the agency or you're the policymaker, then your speech is less likely to be protected than a low-ranking person, right? The public is not going to perceive that a guy who's a janitor or a cafeteria worker at the school is making policy for the school. But when the principal says we should turn the school into a charter school, the public thinks this is a policy speech that he's giving in his principal role, not as a citizen, right? What does it mean to talk about matters of public concern? We mentioned in the Connick case that just bellyaching about your own pay is not going to be protected speech. But when you talk about a broader issue, when you tie it into, right, not I'm underpaid, but everybody in the faculty is underpaid. Professors, teachers are all underpaid. That's enough to transform something into a matter of public concern, says the 11th Circuit, right? Then you get to this balancing issue, right? When does the employer's interest outweigh the employees? And this Rankin case, as these dozens and hundreds of Charlie Kirk firings work their way to the Supreme Court, undoubtedly this Rankin case is going to be the case that the speakers rely on most, right? And the Rankin case flashback to the assassination attempt on President Reagan by John Hinckley, a federal employee, government employees talking around the water cooler with other employees about, man, I really hate Reagan, I hate his policies, and next time somebody takes a shot at him, I hope they kill him. And she gets disciplined, and the court says, well, no, just wishing harm on the president. You didn't say you were going to do it. You didn't say that, that you intended to act on this. Just wishing that tragedy would befall the president doesn't remove this from speech on a matter of public concern. And it didn't interfere with the agency. Some people didn't like what she said, but just making your coworkers annoyed is not enough, says the court, to remove your speech from the protection of the First Amendment. On the flip side, when you do something as a public employee that undermines your ability and your agency's ability to have credibility with the public, right? So a classic example, this McMullen case, you go out and in your off hours, you're recruiting and fundraising for the KKK, right? You don't get to say, oh, well, I was in my off hours. It's just my, being a Klansman is just my hobby job, right? You don't get to say that. No, that reflects back on the trustworthiness of the agency clearly, right? Nobody's going to think that sheriff's office is trustworthy or able to use their government authority without bias anymore once they find out that they're harboring a Klansman, right? And so, of course, the government gets to punish that because that undermines your effectiveness to function as a public employee, and it reflects on the trustworthiness of your agency.
Great. Thank you so much, Frank. So now I'm going to talk briefly about two cases that are controlling in Georgia, one from the Supreme Court and one from the 11th Circuit Court of Appeals. And these both involve K through 12 public employees engaging in speech in the workplace. And so the first one is the Kennedy versus Bremerton case from 3 years ago from the Supreme Court. So this case involved Coach Kennedy, who was the high school football coach, and he had a tradition of praying on the 50-yard line after each game. And in the beginning, he was praying alone, but over time, it sort of became a tradition that his players and even players from the opposing team would join him and he would pray aloud. And that's what's shown in the photo here on the slide. So the school got wind of this. It had been going on for several years, actually, and the school finally learned of it and was concerned that this looked like the school was endorsing the prayer or sponsoring the prayer, which could be an issue under the Establishment Clause, which requires separation of church and state. There was also a concern that members of the football team might feel pressured to participate in the prayer because their coach was doing it and their teammates were doing it. So the school asked the coach, can you please stop doing that? You know, we'll offer you these accommodations where you can pray somewhere else, less public, or you can pray later on the field. The coach was not willing to accept any of those accommodations, and he continued to pray as he had been doing for several years. And so he was suspended, and it was recommended that his contract not be renewed, at which point he sued. And so it made its way to the Supreme Court, and really it was primarily a free exercise claim. The coach was saying that this discipline by the school was interfering with his free exercise of religion. But the court took it up and issued quite significantly that this was private speech, private prayer, even though it was happening at school, because it was happening after the football game was over, when students had the choice to be doing something else other than being coached. And therefore, even though it was in the workplace, it was private, and it was an undue burden on the coach's free exercise to punish his private speech like this. Notably, the court really focused only on 3 of the coach's prayers where he had been praying alone. The court did not really wrestle with the factual complications of students joining the coach and marching band members being knocked over as people rushed onto the field to pray with the coach. That was conveniently kind of set aside by the court. But nonetheless, we have this rule that private religious speech is protected even when it's occurring in the workplace, so long as it's not occurring during instructional time, and so long as students don't feel coerced to participate in it. So then we turn to the Wood versus Florida Department of Education case from just earlier this year, from the 11th Circuit, which is the federal court of appeals that governs Georgia, Florida, and Alabama. And so in this case, we have a high school algebra teacher, Miss Wood, who had been born biologically male, but transitioned to being female and identifying with being a woman, and was using she pronouns in the classroom, and also the honorific of Ms. instead of Mr. And in Florida, there's a statute, actually a state statute, that prohibits public K through 12 teachers and contractors from identifying themselves to students using titles or pronouns that do not match their sex at birth. So under this state statute, Miss Wood was told she could no longer put she, her as her pronouns on her syllabus or write them up on her classroom whiteboard, and she could not wear a pin on her lapel indicating that her pronouns were she, her. And the teacher argued, this is my private speech as I'm a citizen, I'm talking about a matter of public concern, gender identity. This should be protected by the First Amendment. And the 11th Circuit disagreed, and in a narrow but still significant ruling said, you are in the classroom engaging in the speech that you are paid to conduct with students, and therefore this is a Garcetti issue where you have no protection for your speech because it is pursuant to your official duties. And so therefore you have no First Amendment claim over the fact that you've been told you cannot use your identified pronouns or honorific. And the 11th Circuit distinguished this case from Coach Kennedy's situation by saying Coach Kennedy was praying after the game was over on his own time when students could be elsewhere. This, in Ms. Wood's case, this is pure classroom speech. So those are two precedents to keep in mind for K through 12 educators. Moving into the public university setting, there may be more speech protection in the higher education context for classroom speech. This is because of a concept called academic freedom, which doesn't come from the Constitution. It actually comes from a 1940 statement by the American Association of University Professors that championed this idea that professors should have freedom of speech with respect to teaching, publication, and scholarship. And so 30 years later, after this AAUP statement, the Supreme Court in the Keishian case started to recognize academic freedom as a, quote, special concern of the First Amendment. And so this concept gives higher education faculty potentially more protection in the classroom to express their own views and opinions regarding the subject that they are teaching about. So you might ask, well, how does this fit with the Garcetti rule that if you are speaking pursuant to your paid duties, you don't have First Amendment protection? So good question. In the Garcetti case, the Supreme Court dropped a footnote saying we aren't sure that this rule we're announcing in Garcetti would apply where there is academic freedom. And since that famous footnote, a lot of federal courts have held explicitly that Garcetti does not apply to a higher education faculty. However, in the 11th Circuit, we don't have a clear answer on that yet. So that's why I say, academic freedom may provide more protections for college and university professors. We hope that it does, but it hasn't been determined for sure yet. However, we do know that academic freedom will not protect you in the classroom, even if you're at a college or university, if you are injecting your own personal opinions and viewpoints about a subject other than what you are teaching about in that class. So for instance, we have an older 11th Circuit case that said a physiology professor could be punished for bringing his own religious views into the curriculum, and he would not be covered by academic freedom for doing that because the class was about physiology and not about religion. So we have a hopefully significantly different standard for when public employee speech is going to be protected in the classroom for public college and university professors versus K through 12 teachers. I also want to point out that there is a Georgia state law whistleblower statute. So everything we've been talking about now in the presentation up to now has been either about constitutional protections or about academic freedom. But let's not forget about state statute. So this whistleblower law says that an agency, a state agency, cannot take adverse employment action against an employee for certain types of speech. So the protected speech under this statute would be reporting within your agency or to another government agency issues of illegality, mismanagement, waste, danger, or public health relating to public health or safety. So it's only these sort of specific topics that are covered. It's not any general matter of public concern. It's got to be one of these enumerated topics. And then it only protects the speech within the agency or to another government agency. It does not protect an employee that goes public with these concerns. So speaking to the media about these concerns or publishing an op-ed about these concerns would not be protected under this statute. But this is a tool in the toolkit. We don't want to forget that we do have this whistleblower statute. And it applies not just to educators, to any public employee in a state agency. Okay, so to do a little myth busting around First Amendment misconceptions, first, the government cannot take away privileges or benefits in order to punish someone for their speech. So what I mean by that is if you are on the receiving end of adverse action where you've had something taken away from you in your workplace, even if it wasn't something you had a right to or that you had an entitlement to, having that thing taken away from you could still give rise to a First Amendment claim. And we know this again from the Keishin case that I mentioned before. In that case, the court held that professors who were being told they would have their contracts non-renewed if they did not sign a loyalty oath attesting that they had never been a member of the Communist Party would have a First Amendment claim. Even though they weren't entitled to have their contract renewed, they didn't have a right to have their contract renewed, that sort of benefit or privilege of having their contract removed couldn't be conditioned on their signing this loyalty oath. So that's myth number one. Myth number two, there's this idea that the government can prohibit employees from saying anything negative about their workplace. That's not true. Frank talked about this already a little bit, but we have an 11th Circuit case from 2022 that's very much on point, the O'Loughlin case. So there we had two members of the, I think it was the Palm Beach Fire Department, who had created this invitation-only Facebook page where they were talking about, posting about corruption, both within the department and within their firefighters union. And they were punished under a fire department rule that said employees were not allowed to post content that could be, and this is a quote from the actual rule, reasonably interpreted as having an adverse effect upon coworker morale, discipline, operations, the safety of staff, or perception of the public. And the court said, this is way too broad. This rule is going to sweep up lots of protected speech that employees do have the right to say, including this protected speech that these two fire captains engaged in on their Facebook page. And so this is significant because it tells us that employers, if they're going to have policies trying to regulate speech outside of the workplace, they're going to have to draw them very, very narrowly so that they're not infringing on their employees' ability to speak on matters of public concern outside of work. And then somewhat relatedly, there's a myth, well, I won't say a myth, there's a movement by public employers to try to gag their employees and say, you know, you're not allowed to talk about anything related to work outside of work without our permission. We see that a lot, both at the state and the federal level. And these are unconstitutional gag orders, essentially. And we have a Fifth Circuit case all the way back from 1981, which was at a time before we even had an 11th Circuit. So Fifth Circuit cases were actually binding in Georgia at that time. And so this case continues to be binding in Georgia. But it's the Barrett versus Thompson case. And there, a sheriff's office in Texas had a lot of different rules about what employees could say and not say. And two of them that were at issue in this case, one said that you know, you can't be making unauthorized public statements about departmental affairs, period. So basically, if we haven't given you permission to say it, you can't say it. And then the other rule that was at issue is that employees could not speak to reporters. They could not speak to the media on any topic that is or could be of a controversial nature. So very broad and sort of vague about what that means. And the court said, no, these are unconstitutionally overbroad. Again, they're going to sweep up way too much protected speech. And the court said, sure, it's a legitimate concern for the sheriff's office to promote loyalty, discipline, and efficiency in operations, but you can't go this far. You can't be impermissibly gagging and shilling employees in their speech on matters of public concern.
Could I just add two quick points on this, Claire, because this is sort of a special concern for me. First of all, I've often heard people say, well, I know what the First Amendment says, but we go by our own rules here. We have our own policies here. And so people are bound by our rules or our policies. And the answer to that statement is that I know what the First Amendment says is a complete sentence that ends in a period. There is no but. There's no but that follows that. If you have a policy or a rule or a handbook or an employment contract or anything that purports to give people fewer rights than the First Amendment guarantees, that's all legally void and unenforceable, right? And the courts have said this, including in Barrett, over and over and over again. The second point here is like, why does the First Amendment care about this? Why is this a concern of the First Amendment? And the obvious answer is, right, if everybody in the workplace is required to get pre-approval before they can say anything publicly, well, of course, the people who are dissenters and whistleblowers and critics, the people who have what Pickering had, inside expertise and knowledge about wasteful spending, those people are never going to get heard, right? And so that's why these kind of rules are both unconstitutional and also just civically a terrible idea.
Yes, great points. Thank you, Frank. And so now we're going to turn it over to Jerry to talk about some more sort of local cases, again, going back to the K through 12 teacher context, which is where we see so many of these issues bubbling up.
Good afternoon, everybody. Jerry Weber. I mostly practice, but I also teach at Georgia State and Emory Law School in the First Amendment space, and I'm also on the GFAF board. And I'm going to talk really about two things. One, I'm going to talk about some of these recent cases that are either recently decided or traveling through litigation that are illustrative of what we've been talking about. And then I'm going to turn it away from law and more to practical tools that you can utilize if you are speaking as a public employee and if you are harassed when you have spoken as a citizen who is a public employee by others because they didn't like what you had to say. So these first four cases on this slide the first two are cases that are in litigation. One you've probably heard about. It's about a long-term teacher in Cobb County schools who found a book at the school book fair that addressed individuality, inclusivity, and the students wanted to read that book. They voted for it, and then she showed the book. It was a children's book, and she was ultimately terminated because of a policy, and this goes back to Frank's point, that prevented controversial materials. There was no definition of what controversial was, and in the disciplinary proceedings for the teacher, it was revealed that the administrators thought it was when any two parents might disagree. Of course, parents disagree about everything, and so everything was controversial. And so it shows that there are both First Amendment issues that we're addressing here and sometimes vagueness issues where teachers or public employees don't know what they're allowed to say and what not. And that presents a different constitutional issue. The Turner case was just decided initially at an early stage last month. And it's really a teacher who was whistleblowing in a variety of ways about grading improprieties, about failure to comply with federal disability laws. And even she was complaining about violations of school policy because employees were drinking at a school event. And she was disciplined for that. And that case is traveling through litigation now. The Barrett case kind of illustrates that you do have a right, and this is an important right, to speak at public comment at school board meetings or at other governmental meetings if you're working for other kinds of governmental employers. And it's an important case in that space. And then the last case of these is the Hubbard case, where a teacher who was on leave for the Georgia Association of Educators spoke about an issue at the state capitol and was subject to discipline for that. And the 11th Circuit said that even though that person was a teacher, even though they were talking about their own school district, they were teaching or speaking as a citizen in that context. So these cases all kind of play out some of what we've discussed. And now if you'll turn to the next slide, this slide really focuses on what you can do if you are speaking as a citizen to protect yourself. Make sure you have secure passwords. Use multi-factor authentication where you have to verify yourself multiple times. Scrub your private information off the internet. You can Google yourself, you can find out if your home address is on there, if your cell phone number is on there, and you can go to those websites, and there's usually an opt-out procedure that you can utilize in order that your private information is not out there for everyone to read. Your privacy settings. A lot of people don't look at them, but for all of your social media, you can set your privacy settings and set who can and cannot see your materials. If someone is being critical of you on your private posts, you can block that person, meaning that they can't see your post on your site. Or you can delete comments, essentially. They are still available, but you won't see them. So those are tools that you have kind of within social media to protect yourself. And then, of course, you can also sometimes speak anonymously. And if you speak anonymously, you get a press call about something, you have to specifically have a conversation with the reporter about wanting to speak anonymously. And you cannot, that doesn't give you 100% protection because a court may not necessarily protect your identity. So be very careful when you do that, but that is a potential tool that you have available to you. So let's say that you've posted something and it becomes a target of harassment. What should you do? Well, the first thing is to take screenshots and preserve the evidence. I do a lot of social media blocking cases, and you see how quickly the information on social media disappears. So you need to save it. That also goes to phone calls. If you get harassing phone calls, you need to save them. You can report the harassment to the social media platforms. Those persons are subject to potentially being blocked because they violated the standards of Facebook or whatever. Again, you can consider blocking or muting the harassers. And then you can change your passwords. Do things that can assure that the harassment doesn't expand, because there are lots of folks out there online that will try to get at your information, your passwords. There's a lot of places they can do that, and that your harassment will only expand if that happens. Next slide. If you are harassed because of something you've said, you can consider reporting the harassment to school officials, especially if it's harassment from parents or other teachers. Under the Georgia Fair Dismissal Act, you have protections that prevent you from being arbitrarily terminated, and those may come into play. There are federal and state laws. Of course, Claire talked about the Georgia whistleblower statute, but there are also federal laws. Title VII is the most prominent of those, that if you are being targeted by your employer based on race, color, national origin, or sex, and then also under other federal laws for age, disability, genetic information, you may have claims. If you are a member in Georgia, it's either Georgia Association of Educators or PAGE. Those associations will sometimes provide representation in certain circumstances, or you can consult with a lawyer. And generally, a lawyer with some employment law experience is the best thing to do. And the final thing, if you can flip over, and this is if things get really bad, you can report any criminal acts of harassment to law enforcement. There are a whole host of criminal laws about threats, about harassment, about cyber stalking, about hate crimes. And you can report to local law enforcement, sometimes to the Georgia Bureau of Investigations or the FBI. And they will let you know and investigate if there's a potential claim there. And all of this is to protect you because, you know, the Charlie Kirk postings and what has happened in the wake of that and his tragic murder all combined to create an atmosphere right now where people are exposed to a lot of harassment and a lot of discipline and sometimes termination across the country. And those cases are just developing. There's the most recent case was decided 2 weeks ago, Hook v. Rave out of the Southern District of South Dakota. And it is the first case involving some of these comments about the Charlie Kirk assassination. And those cases will continue to develop. And we wanted to save a lot of time for questions, and hopefully we have. And so I'll turn it over to Claire, who's going to kind of monitor our questions.
Yeah, so if you have questions, now would be a good time to type them into the chat. And we have about 15 minutes left.
Well, while we are waiting, I'm just going to put Jerry on the spot here. Jerry, I'll play professor here, and we'll go Socratic. If you have one of those cases, right, you are the attorney for the employee, and the employee says, "I went on social media, I got fired because on my own time, not representing myself as a spokesperson for my employer, I said something that was a stupid, hot-headed comment about Charlie Kirk that I shouldn't have said, and next thing you know, I'm out of a job." What are some of the factors and considerations in applying that Pickering balance that like a court would look at, right, in evaluating whether that is or is not a legitimate firing?
Sure. So I think there's probably three things. One is obviously the text of what is said. There's a whole gradation of comments. Some teachers have been disciplined for simply quoting Charlie Kirk. Other teachers have been disciplined for quoting Charlie Kirk and then expressing their own opinion about what he had said historically. And then there are others that are more closely tied to their school. Now that's a different question. First question I have is, did you use your own personal social media? Were you at work? Were you at home? Did you use your own personal social media? Then I'd want to look at what they said. I'd want to know where they are in the hierarchy. If they are someone that is a principal or a superintendent, they have less of a First Amendment right than if they are at a lower level within the administration. And then the last would be what has happened in the school. Has there been a lot of discussion about this? Has there been any disruption about this? Have you been contacted by any teachers, students, parents? What have you said? So really understanding the context, because ultimately what we're looking at is the weight of the First Amendment right, which is how private was it? How much was it in the kind of center of the First Amendment? And then what happened in the school? Because that's the other side of the equation, because it's ultimately a balancing test.
So we do have some questions. So with respect to the tips on sort of protecting yourself, there was a question about, you know, is the choice that I have to silence myself or face harassment? And I think, you know, that's getting at maybe a separate issue from whether your government employer can discipline you for what you say. So, you know, in the world of social media, there are going to be reactions by other people, and if your social media is public, you know, you might receive vitriol from people you don't even know. And that is a function of kind of the social media culture, which the First Amendment doesn't really regulate, because it only regulates what government actors do to, you know, restrict or censor private citizen speech. What private citizens do to each other is outside of the ambit of the First Amendment. So moving on to some of the other.
Let me just, the question, which thank you, Professor Sanders, that's a great one. You know, do professors have any choice other than to just kind of put themselves on mute, right? I mean, this is both a legal and a practical question, right? You know, in my days as a practicing attorney, I always told people, I can tell you what the First Amendment says. I cannot guarantee that your employer will act in concert with the First Amendment, right? I would never tell somebody, well, here's the First Amendment case law. Ergo, you are completely safe against being punished, right? Because people violate laws all the time. So I can tell you that based on the facts you've given me, either you would have a good or a less than good chance of overturning the discipline. But can I tell you you will not be disciplined? I cannot, right? I mean, this happens all the time, that government actors act sort of in excess of what the First Amendment allows, and then you've got to go to court and fight about it. And that in itself is a very painful process. It costs money, it costs time, it has reputational costs. And so, you know, the answer is always a risk calculus, right? And then the last point on that, you know, we sort of alluded to this, Claire, when you're talking about state action, right? That there is a very powerful doctrine under First Amendment law, the marketplace doctrine, right? That the First Amendment is about protecting the marketplace of ideas. And so while the First Amendment would certainly insulate you against adverse government consequences, right? You're demoted, you're fired, you're given a less desirable assignment, you're passed over for a promotion or a pay raise. What it does not insulate you from is very harsh counterspeech, right? And so, you know, if the institution wants to disown the speech, right? If the institution wants to say, look, you know, what this professor said in no way represents what we stand for and our values, and we distance ourselves from it and we condemn it, that's their right as well, right? They get to do that. They get to participate in the marketplace.
And one thing I would say is look at your social media and think carefully about what suggests that you're speaking for your institution where you're working and what suggests that you're speaking as a citizen. You have an opportunity in all of the social media outlets to essentially have a disclaimer. If you identify yourself as Professor X, that's one thing. If you identify yourself by your name, that's another thing. So the more you can define yourself on social media speaking as a citizen, the more protected you are.
So one question was whether the First Amendment protects staff who are disciplined for their speech. And yes, if you're at a public place of public employment, the protections apply to everyone, not just to the teaching staff.
Yeah, as a matter of fact, it may apply more robustly, right?
Sure.
Because as Jerry talked about, with someone who is kind of held out to the public in a sensitive position where they're perceived as speaking for the institution, that person is going to have fewer rights, right? One of the things the courts have said is that if the speech causes people to distrust that you can do your job fairly and competently, that's probably enough in that Pickering balancing test for the agency to punish you, right? And so the very same thing that, you know, let's just a janitor, right, at the school says something on social media that is racially or ethnically offensive, right? Does that cause the public to think, well, that person's no good at mopping floors anymore, right? Probably not. And so that person actually may get a little more leeway to engage in speech. On the other hand, right, that same racially or ethnically offensive remark might very well cause people to say, I don't want my kid taught by that teacher anymore. And that's enough to override the teacher's First Amendment rights.
So we have another question about Delta Airlines CEO having sent out a letter warning people not to dissent regarding Charlie Kirk. Are you protected under the First Amendment? So Delta, as a as a private entity, is not subject to the First Amendment in the same way that government agency employers are. So would you be protected, if you work for Delta, would you be protected by the First Amendment from having your speech censored by the CEO? And the answer is no, not under the First Amendment, unless Delta has promised or made some agreement to honor the First Amendment rights of its employees, which probably it has not. We see with like private colleges and universities, they will often have free speech protections written into their employee handbooks or into their internal policies. And there you could rely on what the private college or university themselves has promised to uphold in terms of free speech rights. But it would be rare for you to see sort of a commercial conglomerate like Delta promising to uphold its First Amendment or its employees' free speech rights. So,
And the only thing I would add to that is that if the post is about an issue of race, which it could be for posts about Charlie Kirk, because he certainly spoke about the issue of race. And if the employer, whoever that may be, was applying its policy in a differential race, in a differential way for speech about one side of racial issues and not other side of racial issues, that could potentially present some Title VII issues. So there are, there's these other federal statutes that are out there that may present issues wholly apart from the First Amendment.
And real quick, just so for completeness, so people are aware of this, right? There's also the National Labor Relations Act, the NLRA. And while the scenario in the chat doesn't seem like it would lend itself to that at all, under different circumstances, if someone is speaking out in a way that is intended to sort of call attention to workplace concerns, and particularly if what you're trying to do is like mobilize your coworkers or mobilize the public, right? So this workplace systematically underpays its employees, whatever, right? In a way that is intended to advocate for better working conditions. That may very well be protected speech under the NLRA, which is fascinating because it's probably not protected speech in a public setting under the Connick Doctrine. And so you actually may have more rights as a private employee if the NLRA applies to your workplace than you do in the public sector. Again, not applicable to the exact scenario here, but just so people are aware that that body of law exists as well.
So I have a question that just came to me directly, so I'll just read it aloud. It says, is clothing with speech on it protected? Hypothetically, could a college instructor wear a shirt that says abolish ICE, even if they do not discuss it in class? So that's an interesting question. I think, when you are in the classroom teaching, even if, you're not speaking aloud, but you are, you have this shirt or button or whatever that has messaging on it, the same rules are going to apply as to whether you said it aloud or just wore this piece of clothing that displayed it. In the K through 12 context, it's likely not going to be protected at all. In the higher education context, it could be protected under academic freedom if the messaging relates to the subject matter of your course. If it's unrelated, it's not going to be protected.
And you also definitely need to look at the policies of the workplace to determine the scope of that.
So a couple more questions. This also just came to me as well, so I'll read it aloud. It says, as faculty and students, we work around the clock on weekends too. What is considered work hours in a higher education institution when posting on our personal social media? So yeah, that is a good question. It's the lines of workplace and non-workplace do get very blurry for professors who are, engaging in research and writing, and a lot of their sort of official job duties when they are at home or outside of the 8 to 5 work day. I think that's just going to be a very fact-specific inquiry as to whether you were speaking in your personal capacity or pursuant to your official job duties. One thing I've seen people do on social media is to explicitly say, like, I make this statement in my capacity as a private citizen. You know, this does not represent the views of my employer, just to be clear about it. But I think at the end of the day, it could just become a very factual analysis based on the specific situation of what occurred. I don't know if Frank or Jerry would add anything to that.
Yeah, I mean, the only thing I would add to that is I think when Jerry talked about sort of, are you doing this on the job or not? That's really for somebody who's kind of got the classic 9 to 5 job, right? Where like you can imagine that if there's a bunch of posts on X going out and they're at 10 a.m. and 10:30 a.m. and 11 a.m., right? That like it's more likely that a person in the audience might perceive, well, clearly you're at your desk at that time, and clearly you're on the job, and you're taking time away from your 9 to 5 job when you're on the clock and for what you're paid to do, right? So that's going to be like a factor that would go into the balancing. Is it the conclusive factor? Probably not, but just harder, right? A little bit harder for you to establish that I was speaking as a citizen, because the employer can say, well, that's not what we were paying you to do at 10 and 10:30, 11, right? So I think it's easier. I honestly, it'd be hard pressed for an employer to say, well, Claire, because you often read Supreme Court cases at home at 9 o'clock at night, that means you're on the clock, because they don't want to pay you for those hours, and they don't want to give you overtime for the time you spend at your dining table. So I think that would probably prove too much. I don't think that I don't think you're always considered to be on the job just because you work extra hard.
Yeah, and even if you're somebody who's not driven by a clock for their job, I mean, you shouldn't be using the employer's computer, because that's a factor that may come into play, even if you're posting on your own private social media. If you're using the employer's computer, that may be a fact. It's probably not going to be dispositive, but it's a fact that'll come into play.
So I think we have time for one more question. There's one here about what if you post anonymously, but your identity is discovered and your employer disciplines you for your speech, even though you tried to keep it anonymous. As for instance, if you posted something about Charlie Kirk. So I think the fact that you posted anonymously is not going to be dispositive of anything, right? Like, I think the factors Jerry enumerated as to like, what did you say? What is your position within your organization? Are you high ranking or low ranking? Those are the factors that are, what was the impact on your workplace from your speech, if any? I don't know that trying to say it anonymously really changes the balancing test between like your private speech rights versus your employer's right to have a smoothly functioning, efficient operation.
Yeah, the only thing I think it might go to is a number of policies for employers require some intent, and that the anonymous nature of the speech could go to intent, and that may be helpful.
The same person asked 2 comparable questions. So to question number 1 and question number 2, my answer is the same. All of these things are factors that go into that balancing, right? If you spoke anonymously, then I think it is harder, right, for the employer to say that somehow you held yourself out as speaking for the agency or were perceived as speaking for the agency, because it's like, well, no, I just used this screen name, Charlie123, right? So clearly I was not in any way representing myself as a spokesperson or an official or whatever. But that's also going to go to the content of the speech, right? If you say as a 20-year employee of the school district, blah blah blah, well, then the fact that you use Charlie123 is not going to insulate you against being found out, and it does seem like right now you're tying it back to the school district. So it's a factor, but not dispositive. Same with the idea of a disclaimer that Claire added. It's helpful. It's not going to bulletproof you, right? Again, going back to the 11th Circuit case about a principal, right? So if a principal speaks out about a matter of school policy that looks like a policy declaration and puts a little PS at the end and says, this is just my personal opinion, I don't think that's going to be a conclusive factor if all the other factors are pointing that this was official duty speech. It goes into the mix, but I don't think it's decisive. Oh, and someone asked about liking and sharing a comment. So this comes up from time to time, and I will say that that is a door that swings both ways. There is case law out there that says that a like or a share is itself First Amendment speech. And so your employer cannot say, well, all you did was click like, that wasn't speech. That is actually speech. It's regarded in the courts as, yes, you have indicated affirmatively approval of the comment. And so at least some First Amendment protection comes into play, but the door does swing the other way too, right? That like, if you sort of attribute the remarks to yourself, and particularly if you help share them out, right? So that we see this from time to time in like the law enforcement context, somebody will share out a bunch of racist speech online, and when they're challenged about it and they're punished, right? They'll say, well, I didn't do anything. All I did was push retweet, or I pushed a repost on Facebook and Instagram. And the answer says, yeah, you still spoke. You still spoke. So that speech is still attributable to you for disciplinary purposes.
Well, we are at 1 o'clock, so I want to thank everyone again for joining. We will be posting the video, or GFAP will be posting the video to their YouTube channel if you'd like to rewatch or share with others. Again, please feel free to reach out if you have additional questions to either the Georgia First Amendment Foundation or the UGA First Amendment Clinic. Thanks,
Thank you.
everybody.
Thank you all.
Have a good afternoon.